Hello, I'm Dominic Walker, JMW's Inside Man, and I'm with Katherine Smith. Katherine is a Senior Associate at JMW's Manchester office, and she deals with court of protection work. Hello, Katherine.
Hi, Dominic. How are you?
I'm very well, thank you. So we wanted to talk about the high-profile case, really, of Britney Spears. It's been in the press an awful lot, talking about her father's conservatorship over her. And I mean, I suppose that's quite an American term, isn't it? How does it translate into the law of England and Wales?
Yeah, so in England and Wales, it's known as a deputyship. The Court of Protection, they will make a decision. They will appoint a deputy if medical evidence finds that someone lacks capacity. There are two types in the UK: property and financial affairs, and also health and welfare. Deputies operate following the principles of the Mental Capacity Act 2005, and it emphasises that the person's best interests are paramount. The person is to be included in all decision making, supported where necessary, and again, ensure that that best interest is kept to the fore.
You mentioned best interest, so clearly that's of paramount importance. Who can be a deputy, Katherine?
So again, drawing parallels with the Britney Spears case, it usually is close relatives or a friend. You have to be over 18, able to manage someone's affairs. It can be a joint appointment, or one person can act on their own. Professionals such as solicitors, local authorities can act. At JMW, we act as professional deputy. If absolutely no one is available, there is a list of approved deputies called a panel deputy, and at JMW we are on the list of panel deputies. In England and Wales as well, the deputies supervised by the Office of the Public Guardian. We submit accounts every year to show where funds have been spent and why they've been spent on a certain item or transaction. The Office of the Public Guardian will raise questions if they're not satisfied that was made in best interest, and just clarify. Professional deputies do charge for their work. Those bills of costs will go off for independent assessment, and only reasonable costs will be allowed. Again, it's slightly different in the US from what I've read. So yeah, quite different.
Now, I don't know if 90s pop icons walk into your office very often, Katherine, and I'm sure you won't tell me. But what I do know is that you deal with a lot of high net worth individuals and ultra high net worth individuals. What's your practical advice in somebody in sort of Britney Spears' type of situation?
So again, if a similar situation arose and that person wasn't happy with how their finances were being arranged by their deputy, the first thing we do is probably look at their capacity, because it may not have been assessed for a while. We'd probably check if there's a possibility that they can be discharged, take on more of an active role in their finances. If the medical evidence says that the deputy is still required, then again, we've talked about best interest, continuing to act in that way, we'd look at possibly applying to the Court of Protection to make a change to that deputy. We can help with all sorts of applications to the Court of Protection, applying as deputy in the first instance, making large gifts from estates, and also when making a will if that person is deemed not to be able to make it themselves.
Excellent. Katherine, it's been fascinating to talk to you. Thank you so much. And if you'd like to speak to Katherine, you'd like some advice, you can contact her via me, insideman@jmw.co.uk, or call on 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.